Scott yesterday on some national program. I saw Lanita Baker on one. It's awesome. Okay, I'm going to start recording. Hello, everyone. I think we have everybody here. So we're doing the shortened, modified version. So really the way you should think about a summer class, we're really doing 2 weeks of material in one. So it's really compressed and expedited. But even in that format, I didn't want us to be doing too much live time because as we all are keenly aware, there's just limits to how much you can do in this kind of a format. The way we're going to structure these sessions, for the first 2 sessions, we're covering material that I personally can't conceptualize how to teach Roe v. Wade online. Like, I just can't. So I personally think that live conversation about some of these current events, cases, things where we're really talking about murky concepts where it's unclear what the scope of the law is, are really well suited for online and for discussion. So that's what we're going to do in these first 2 weeks. But ordinarily, after the first 2 weeks, the way this online session will work is it will work much more like a live lawyering simulation. So we're going to meet clients in a couple of weeks. And from here all the way through to the end of June, we're going to represent them in each of the components of their family law case. So we'll represent them in dividing property, calculating child support, litigating child custody, litigating visitation. So ordinarily, these will be much more interactive. We'll do breakout rooms. Half of you will represent one spouse, half will represent the other. So for these first 2 sessions, though, we're covering our constitutional law material. And so to frame it for us, I just want to emphasize that the constitutional law material will ultimately be tested as 20% of your final exam. So at the end of this, I think it's helpful to be super candid from the beginning, what your exam will look like, what the expectations are, because it helps focus your notes, focus your studies. So the way you can expect your exam to work at the end is 20% will be a con law question. And what I mean by that is I will give you some provision that is usually pretty wackadoodle and always unconstitutional. I don't think I've ever given one that's constitutional, but some form of state regulation that regulates the family. It might regulate reproduction, it might regulate parenting, it might regulate marriage, and your job will be to objectively analyze its constitutionality. So usually what I do is I have you representing like a committee that works for a state assembly, and you're advising the local legislature on whether it is or isn't constitutional what's being proposed. So that's what you're leaning towards. So you will not be tested on Roe itself or Loving itself or Obergefell itself. You'll be tested on concepts, right to privacy, right to marriage, right to raise and rear your children. You'll get an exam question. You'll scour the question to figure out which rights are implicated, and then you'll apply the doctrine to that case. And so I think that's helpful context, because I think a lot of people know that I am really interested in reproductive rights. I am really interested in marriage equality. I am really interested in like the specific topics we're talking about, but that's not really what we're studying. What we're really studying in this unit is the outer bounds of constitutional regulation of the family. Almost all of what we think about as family law is delegated to the states. What can the state do and what can't it? So we can think of the sort of federal constitution as like an outer perimeter within which states can regulate. So that's what we're leaning towards. So to give you an example, many years ago, my question was state law that would ban a liquor sale to a visibly pregnant woman. Well, what the heck is a visibly pregnant woman? How many ways can that go wrong? And why can't we sell it to her, even if it's not to consume? Can't I buy a bottle of bourbon to bring to someone as a house guest? And so you had to analyze that through the lens of the rights of pregnant women, through the lens of the right to privacy, and reason through that it's likely unconstitutional for these specific reasons. So that's where we're moving to at the end. I'm not going to spend a lot of time reviewing our course because hopefully you've watched the video, or you will watch the video, and hopefully you've read the syllabus. But I do want to open it up first if anyone has any questions about what's going on with week 1 so far, with any of the modules that are online, with getting a book, any questions at all before we jump into substance.
Did you say that you do have an extra book?
I have one in my office. If somebody that I could get to, one of the old editions that I would eventually have tossed. So let's follow up offline, and I'll have to think about who's on campus who can get it to you. But if I can get it to you, it's yours.
All right, sounds great. Thank you.
Yeah, absolutely. And then let me just close my thought on the exam thing. So I told you 20% of the exam is this con law question. I actually don't call it a con law question. I call it a policy question. The other 80% is bread and butter family law lawyering. And I can tell you exactly what the questions are right now. Does the couple have a valid marriage? Does the couple have grounds to divorce? If so, where can they divorce? When can they divorce? And how can they divorce? How will their property be divided? How will child support be calculated? How will child custody be decided? How will visitation be decided? That's your exam. So it's super predictable. So the way I encourage you to approach this, especially in this condensed, fast-moving summer session, I encourage you to approach the material and it's an open book exam. So I encourage you to approach it as if you're moving toward preparing your open book exam materials. So for example, next week in class, we're going to study grounds for divorce, and I have you make a chart. Surprise, if you've had me before. Love my chart. If you do a really bang up job on that is your study tool. And then when you walk in and take your open book exam and you analyze whether there are grounds for divorce, you'll just scan the chart and that's what you'll use. So a lot of the things that you're doing in the online content is to prepare you for exam success. And ordinarily, with the exception of these first 2 weeks in this lab, we will be practicing exam readiness. What are the client counseling points? What are the ways to structure an answer? That's what we'll ordinarily be doing in here. I want to also just mention at the outset that this material that we're studying is incredibly timely, particularly today. At any day starting yesterday, between now and the end of June, the U.S. Supreme Court will be publishing a new opinion that we'll talk about in a moment that will reconsider the issues in whole woman's health. So if you've probably seen in the news, these sort of so-called deathbed confession of Norma McCorvey, the plaintiff in Roe, lots and lots happening in the news. So I couldn't be more excited to be talking about this tonight because there are lots of current events that we can touch on as well. But before we get to any current events, I'm going to start with a historic run-up. So what we're studying here is hands down, probably ultimately by the time we get to Roe, one of the most contested Supreme Court decisions that has ever been published. And so I like to study this. First of all, I like to start by clarifying we're not studying abortion. We're studying the constitutional limits on the rights of states to regulate families and what the standards we will apply to our future policy or law that I give you on the final exam. But I do think it's helpful because it's impossible to not acknowledge the controversy surrounding Roe, particularly the way it was decided, the way it was written, and what it said. So what I like to do with this unit is we're going to basically do a full chronological run-up. And you probably cursed me several times when you worked through the readings, when I had you read them in chronological order. And that's what we're going to practice today. So I'm going to start us off. We're going to start with Griswold just to get our bearings, and then you'll see what I mean about the chronological order. So I think I have Johnny first. Johnny, are you there? I see you.
Yes, I'm here.
Hi. So why don't you start us off by telling us what the statute was at issue in Griswold? It should catch all of our attention.
The 14th Amendment statute.
But what did the state of Connecticut say?
I'm sorry. That's the U.S. Constitution. I'm sorry. The statute, state of Connecticut, it's a statute that bans, I won't say bans, but it prohibits any information or instructions on medical advice to married people that that focus on conception. So if you talk about conception or give instructions about conceptions, you are to get arrested.
Yeah, so ban actually is the perfect word. It's a complete ban on any person. And you're right to slip in married people, because that's eventually where the court is going to go. But I want to emphasize that the statute was not that narrow. It was initially any person who uses any drug article for preventing conception shall be liable for $50 or imprisoned not less than 60 days. And not more than 1 year. So we're talking about a criminal ban on the use of contraception by anyone, including married people, where the court will ultimately focus, but absolutely and especially also including unmarried people. Now, this law had been on the books for 86 years, but by the time we get to this year, 1965, it's the only one left. And I want you to compare and contrast that to Roe. When we get to Roe, and all the controversy that Roe creates, every state in the country is watching what happens in Texas, because every state in the country has a law similar to what was at issue in Roe. So much more controversial and much more watched. But Griswold was the only one of its time left. And I'm going to do what I call all-ins, and that's only because I think it's probably not appropriate to call it a group social, like a drinking reference. We're going to do sort of all-ins where I want you guys to type in the chat box. And this is just a chance to get a more inclusive kind of participation. So in the text box where everyone can read it, so over on the right, I want everyone to make a quick note contextually, because we're so far removed from that. We use contraception so regularly in our ordinary lives now that I want to just take a moment to reflect on what life would have been like under this Connecticut statute. So in the text box, I want you to make a couple notes, and particularly pause for a moment and think about who you're describing. What would be the differences by class? What would be the differences by marital status? Might there even be differences by immigration status or race? So in the text box, I want you to just pause and provide a sentence or so, give an example of how on the ground in 1965, a law that made it a misdemeanor to use contraception would have affected real people. Good. So lots of different. Good. I love the baby boom references. Yes, good. So it definitely would have affected population, but also there would be real class disparities here, because this is only the law in Connecticut, right? So it really has to do with how much state scrutiny you fall under. How is the state going to know if you're using contraception in your marital bedroom? What are the ways in which people interact with the state? Do you interact with the state in housing? Do you interact with the state in medical care? Or are you outside of those systems and in more private networks? So the likelihood of being caught was particularly high at public clinics. So where the arrests were happening were at public clinics, and we can see lots of modern parallels today. If you had a private doctor and you're in Connecticut, you might nonetheless be able to find access to contraception. You might nonetheless be able to get it from a neighboring state. And then furthermore, if you become pregnant and you didn't want to become pregnant, there are real serious health disparities as well. And so there were a few references to disparities throughout here, a couple, but I'm going to mention it. I'm going to pop up my slides here. This particularly would have real life and death consequences in some communities. I'm going to pop up here. This is a picture of maternal mortality rates. And so we're talking about a law that had been on the books for 86 years. So it's 1965 right now, but we're going all the way back into the 1800s. Take a look at the difference between where on the left here, where our maternal mortality rates are now out of per 100,000 deaths compared to where they were in 1935. So not just the risk of abortion, but the risk of death, right? Because it's probably more likely that you might carry an unplanned pregnancy to term. And with that came real maternal mortality risks. If we look in the column on the right, particularly, and this is a modern statistic, I want to mention that maternal mortality is still a real issue and really heavily implicated in contraception access and abortion access, but particularly racialized today. So look at those numbers: 3 times higher maternal mortality rates for Black women than non-Hispanic white women, and notably higher for American Indian, Alaskan Native women as well. So I mentioned that just to put in context this law that we're talking about here. So we always study it and we just sort of fly past it and we take the right to privacy out of it. But if we just imagine what life would have been like then, it would be notably different and notably stratified as to how this law would affect various people. So Johnny, let me come back to you. How did this lawsuit come to be? It's kind of a quirky little story that the textbook describes for us. How did we come to bring this suit? It didn't just happen. It was quite planned. Kind of funny case about contraception. Anyway, sorry.
Yeah, so do you want me to start all over, like, for us, give you the synopsis and kind of break it down, or?
Tell us who got arrested here specifically and how it happened.
Okay, so Griswold and Bexon were arrested for giving information, instructions, and medical advice to married people, preventing conception. They were arrested and convicted based on the Connecticut statute that prevented contraception. For some reason, I like to call it birth control for some reason. So I don't know. So they got arrested based on that for assisting married people and wanted to use it.
Good. And notably, when Griswold and Buxton were arrested, if you saw in the little write-up after the case, they planned this. This was a strategy. They put a clinic together knowing they would be arrested. And let me bump to Nathan for a second. Nathan, I asked you to be on call for the Poe v. Ullman case. Tell us about that. Why did Griswold and Buxton have to get themselves arrested? What happened in Poe before we get to Griswold?
Well, in 1961, to that point, nobody had actually been arrested or prosecuted for the offense, and so the Supreme Court said it was unripe, so they didn't have standing to challenge.
Good. And do you remember anything about who were the plaintiffs in that case in Poe? So Poe is the precursor to Griswold, and who were the plaintiffs there? It's very different than what ultimately gives us this right to privacy.
Well, it was a married couple and their doctor that was challenging the law, but they were doing it.
Why were they afraid of the impact of the law?
Right.
Do you remember why? Like, what were their specific conditions or concerns?
There was a medical condition that caused the wife to not be able to carry to term. And so she wanted to seek medical advice on contraceptive.
Good. And so if you go back to the sort of all-in that I had you participate in, when you talked about who this was affecting, it's affecting everyone: married people, unmarried people, LGBT people, poor people, wealthy people, immigrants, non-immigrants. But ultimately, the first version of this case was a much narrower version. The people that they brought forward were people who were as compelling as you could possibly imagine, married couples where the birthing woman would likely die if she became pregnant. That's a way narrower version of the case that we ultimately see in Griswold. And Nathan, what happened? Did you happen to catch what legal theory was supporting this initial Poe case?
I don't remember that.
So So just to put it in context, this is 1961, and this is a case brought by women's groups. And so I like to start here instead of starting right in with Griswold, because I think it's helpful to just wrap our minds around how and why we're even talking about the right to privacy. Because if you think about what the women's movement was all about in the 1960s and the 1970s, the last word that would come to your mind would be privacy. Instead, you might think freedom, liberty, autonomy. It was much more about bringing the state into the marital bedroom to stop marital rape, bringing the state into the home to stop domestic violence. And so it was much more about liberties and freedoms. And did you find it, Nathan?
Yes. It talks about having police power to go into the marital bedroom and inspect.
Good. And what were the advocates saying in Poe was so offensive about that?
That's there's a sanctity in the marital bedroom, in the intimacy of marriage.
Good. So they really package it much more traditionally in textual language around a constitutional right to life and liberty. And I think it's helpful to start with this because it does kind of beg the question, and it is a fair critique, regardless of your politics, where this right to privacy comes from. And that's the biggest critique of Roe v. Wade. And I think it's important. This is the moment where it's happening. So the lawyers bring this initial case and they want to strike down this law banning contraception as unconstitutional. And they want to do so through the lens of the right to life and liberty, the liberty of the married couple in their bedroom is really what the court is talking about. But instead, what happened to that case, Nathan?
The Supreme Court said that because the couple hadn't actually been prosecuted, that they didn't have standing, and that it was unripe. So somebody actually had to be prosecuted or be injured to actually seek remedy.
Good, perfect. So the court strikes it down, sends them home. And that's why Griswold and Buxton have this dinner party where they decide that they're going to open a clinic for the purpose of getting arrested. So it's a very conscious and a very bold, frankly, legal strategy that comes out of Poe. And we're going to talk in a moment about this with Nathan again, but there was a dissent. Did you happen to catch the dissent, Nathan?
I read it, but I don't remember.
So the key point, the majority dismisses the case on standing grounds. The dissent would have heard the case, and it's authored by Justice Harlan. And Justice Harlan says, you know what this case is really about? This case is really about what, Nathan?
Let's see.
Did anybody catch it? He recasts in the... Go ahead, Johnny.
He captured due process. Case, with these, some of the, how they concurred, Harlan. He's talking about Harlan.
In the Poe case. So the Poe case, they have this super compelling, very, very tragic facts. If these women were to become pregnant, they would likely die in childbirth. The court kicks them out and says, yeah, but you haven't actually been prosecuted under this law, so you have no standing. The court says no standing. And in this dissent, Justice Harlan says, you know what? I think this case is really about privacy, the right to privacy and keeping the state out of the marital bedroom. And I think that's really important because if you imagine yourself at this dinner party that your textbook describes between Griswold and Buxton, where they're brainstorming it, this began as a movement for freedom or liberty or the right to liberty. But what are you going to do when one justice hands you on a platter an argument? And that justice says, I think this is really about privacy. So those advocates bring this case, but they also have to re-envision their entire strategy because one Supreme Court justice told them that they thought they had a case if they brought it in a totally different way. Does everybody see why that's so incredibly significant? It was like they tipped him off with a note under the table how to re-bring this case. So that's exactly what happens. So now we have this little morsel handed to us saying, try the right to privacy. I think that's going to work. And now these advocates have to try to build this right to privacy out of the existing authority. And we're going to do a historic run-up. So I had a lot of folks on call for this material particularly. And so I'm going to have what I want us to do is imagine you're the lawyers. Oh, sorry, got squeezed out. Imagine you're the lawyers in this case and you are constructing the authority and you have to build this right to privacy up. How are you going to construct it? What are the building blocks? So I'm going to start us off because Shelby was on call, but I think she's not in the class anymore. So I'm going to start us off. So the first source, these go in chronological order, that the advocates cite to in coming up with this new repackaged hope to try to strike down the statute is to cite to the Louis Brandeis Law Review article, one of the most famous law review articles with our law school's namesake on it. But it's kind of crazy. It's really like way more juicy and interesting than this case even is. And so it was a law review article, which all of you from lawyering skills, your radar should be going off and saying, how is the top of this list a law review article that we're about to cite for a new right set forth under the Constitution? But in this law review article, Justice Brandeis was reflecting on a recent wedding of Samuel Warren. And in his reflections about a wedding, he talks about the right to be let alone. And specifically what he's agitated about is the ways in which modern camera technology, so think TMZ and paparazzi here, invaded the space of Samuel Warren's, I think it was his child actually, who was getting married, but it was the right to be let alone, but it was really more about technology, and it was more analogous to the kinds of ways in which we can use technology to invade people's space. So that's our first authority, and you're trying to construct a brief to the United States Supreme Court, so we shouldn't feel super confident yet. Our second authority that talks, so imagine this is like your legal research assignment, and you're looking for anything and everything that builds on this little morsel Justice Harlan handed you, saying try the right to privacy. So the second morsel you find as a researcher is this Union Pacific v. Botsford case. And this case is crazy for all of you who've had me for torts. I hope this makes you cringe. But it was a torts lawsuit in which someone was injured. And they wanted in discovery, they issued a discovery order, a request seeking that the person who was injured present themselves to a surgeon to be surgically evaluated for the extent of their injuries. And that should catch all of our attention. And not surprisingly, the court said that that was too intrusive and that the plaintiff had a right to be left alone. Similar language. The right to be let alone and not be compelled forward for a forced surgery to assess a damage claim in torts. So that brings us to Meyer. I hope nobody's feeling super confident yet in this right to privacy we're about to construct. So Ellen, let me come to you with the Meyer case. Why don't you tell us about that case?
Yeah, so in Meyer v. Nebraska, basically under Nebraskan law at the time, it was a crime for any individual or a teacher to teach a subject any subject where they're having a language being taught other than English if the child was under the age of the 8th grade. And so at the time, Meyer was a teacher and he was convicted of the Nebraskan statute because he was teaching German to a 10-year-old student. And so do you want me to go ahead with the holding and everything?
Yeah, go ahead.
Okay, yeah, so basically the holding was that under the Due Process Clause, there's implied liberties that can be found within them, even though they're not expressed within the language. But these liberties interests couldn't be inferred from arbitrary or unreasonable legislation that doesn't further the legitimate state purpose. And so basically the court found that while apparently the reasoning for the Nebraskan law was that during this time, it was right after World War I, and so they were trying to, I think they were trying to create some kind of more nationalism within the country, and so they didn't want their students to be taught anything other than English. And so while the court thought that was a legitimate purpose, they didn't think that it was as closely related as it could be to where it didn't violate the due process.
Good. So everybody in the chat bar, what words did we not hear? Ellen just told us a beautiful story about this case. It was flawlessly discussed and summarized. What words did she not say? If we're the lawyers for Griswold and we're trying to bring this. Good. What else? Privacy is definitely one. That is absolutely not. But who was she talking about compared to who we are talking about? Good. It's really about children, teachers, education, nativism, nationalism, all this fear of outsiders. But none of the kinds of things we're about to use this case for are really there. There's nothing about married couples. There's not much about parents and children. And for those of you who've already had con law, of course, it should scream off the page to you that this is a Lochner era case. Lochner is not relevant at all for our mastery of this, but a very pro-contract kind of time frame. So here, the idea that you could contract as a teacher with the school or as a parent with the school, it's not surprising that the court gave this a strong endorsement. But notably, this is the first iteration of what we will come to call the substantive due process notion. The idea that the liberty rights expressed in the 14th Amendment go beyond the text of the language, and they include other substantive rights. And so here, the court strikes this down under the 14th Amendment on due process grounds and notions of liberty, that this was an improper constitutional deprivation of liberty. Next, DJ, walk us through the sister case, which is actually the Society of Sisters. That was decided just a couple years later, very similar.
That was a case that was brought by two private schools. So they were challenging state statute that said that you basically have to, you're required to educate your children, and it has to be done in public school. And they said that it interfered with the parents' right to choose whether or not their kids were taught by nuns or military schools, which lends me to believe that they might need a little bit more discipline than could be provided in public school. So the court held that the states can require parents send their children to school, but they can't say you have to send them to school and it has to be a public school.
Good. And what's the constitutional authority cited for that proposition?
It's the 14th Amendment again.
Good. Perfect. The 14th Amendment, and it's officially the due process language and liberty notion. So the idea that there's a substantive interest beyond just procedural, a substantive right to liberty here. And notably, we start to hear references now to parents and to children, but we also are still talking about schools and teachers. So we're getting closer, and you can see why these two cases are often thought of as sister cases, because they're both espousing the same rights under the same constitutional authority. And this one gets us closer to a family framing. So we're working through our list, though, but none of this should be, putting your pen to the paper to start writing a winning Supreme Court brief. This is a very tenuously constructed argument at Griswold, though it happens before Roe. Brian, you have the next two cases, Skinner and NAACP.
Yeah, so Skinner was a man in Oklahoma who was convicted of multiple crimes. He was convicted twice of armed robbery, and I believe the third was robbing or stealing chickens or a crime of that nature. And Oklahoma passed a law in the 30s that forced sterilization of repeat offenders. And so he was going to have a forced vasectomy. He appealed it as unconstitutional under 14th Amendment Equal Protection Clause. And he appealed it to the Supreme Court, and the Supreme Court said that forced sterilization is unconstitutional, and it talked about how marriage and procreation were important to the survival of the human race. And then in the equal protection, it talked about how somebody convicted of a crime that was not of moral turpitude, like embezzlement, which is similar to robbery in some nature, would not be sterilized, and that violated equal protection.
Good. And note here, the court is talking about strict scrutiny. So the other cases were, that's the highest form of scrutiny that a court could apply in looking at what a state has done or a piece of legislation. And so this is an important case because it starts to suggest that whatever these rights are that are loosely starting to come together around this idea of a right to privacy, that they should be well protected. And that's what we see in Skinner and NAACP.
Yeah, so NAACP, the Attorney General of Alabama wanted to compel the NAACP to reveal all the names and addresses of its members. I think it's important to remember that this was in 1958, so the context of what was an especially racially hostile environment at the time, and that could have posed a really big threat to members of the NAACP. And then they appealed that it was a violation of the Due Process Clause of the 14th Amendment, and they believed that a state could not compel an association to reveal names and addresses of all its members. And the Supreme Court said that the freedom to engage in association of beliefs is protected by Due Process Clause of the 14th Amendment, and it emphasized freedom of association as important. And that sort of extends to concepts of other relationships that I think could be applied in Griswold.
Good. So the number one word that comes out of the NAACP case is the concept of the penumbra, the idea that emanating from all of our protections around the First Amendment has to be this idea of privacy. And so that's, you can start to see, I hope you're following along with this, that this is a tenuous construction of lots of building blocks, each of which is contributing something. We're starting to think that the state doesn't get to interfere in some of these decisions. We're starting to think that we should give heightened protection to that. We're starting to think that the words in the Constitution might mean more than their explicit language. And then the final source that we can cite to is that dissent, where Justice Harlan in the dissent says that when we talk about liberty, embedded within the idea of liberty is the concept of privacy. And so he says that there are broader substantive protections which are not reducible to due process in procedural terms. So this is it. Imagine you're the lawyer who hired a law firm to write your brief for Griswold. So all the controversy we hear about Roe and where this right to privacy came from, I personally think actually more properly sits here. You can see the tenuous construction of this right. And the court, and it's really coming from this morsel handed to the advocates to go this other way instead of this liberty direction. And Annie, let me come to you, and we're going to go back to Griswold now. So with all this authority put together, and what we've done is we've now done a historic chronology of every single piece of authority cited to in Griswold. What right does the court adopt in Griswold based on all of this precedent? What does the court adopt as the right to privacy?
Let's see, that the governmental purpose to control or prevent activities constitutionally subject to state regulation may not be achieved by means which sweep unnecessarily broadly and thereby invade the area of protected freedoms, and the freedoms
are the ones in the penumbra of the First Amendment, Third Amendment, Fourth Amendment, Fifth Amendment, etc.
Good. Lots of important things came out of what Annie just said. First, in the way she was describing this, she's describing this as this kind of outer limit. That's what she's describing. This idea that whatever the Constitution says, emanating from all of these rights, the right to not have to quarter soldiers in your home, to protect you from unreasonable searches, to not self-incriminate yourself, embedded within all of that conceptually or emanating from the penumbras is this idea of privacy. And notably, though, the court does not, in Griswold, put it in the 14th Amendment, where Meyer did, where Pierce did, and where Roe is. So if you're taking notes on this, Meyer, Pierce, and Roe see this right more squarely as the substantive due process right. And that's the critique that Roe takes most bluntly. But here, the court instead sees it emanating from these other rights within our Constitution. And what does he see, Annie, what does he see as the protected individuals here? Is this really about everyone? If we go back to our all in from earlier, we had all sorts of interests that we were thinking about. We were talking about LGBT people, we're talking about class differences. Who is he actually protecting here, Justice Douglas?
He's protecting the marriage relationship, people who are married.
Good, and that's absolutely right. But notably, that was the Poe case, right? The Poe case were these freaking compelling plaintiffs who were just the perfect plaintiffs you could put forward. People would suffer these tragedies if they were to conceive. This case was about two people who conspired over wine at a dinner party to open a clinic to get arrested. The married people are not in this case. And so you can see a real conservative frame around who gets this right. So it's not that the right has to do with sex or with non-procreative sex or with non-marital sex. It's the marital relationship and the home. And so I want to use this, if you're taking notes, this is the perfect spot to start to sketch out the right to privacy. And so the right to privacy has often been described, use my whiteboard here. The right to privacy has often been described in three different ways. It's been described in a locational sense. Whoops, lost my box. A locational sense, a relational sense. Now they're just going to sit randomly on here just because. A relational sense and a decisional sense. And that's three different ways that we could think about the right to privacy. And if we try to chart that to all the cases we're going to study with the rest of our time left, you'll see in Griswold, this has a heavy locational sense, the idea that the criminal law wing of the state could come into the marital bedroom. It's not bedrooms generically, it's marital bedrooms that he is upset about. And relational, who's the relationship? It's the married couple. So that's where we come away with Griswold. We spent a lot of time on Griswold because notably, I think Griswold deserves more time than Roe, because really this is where we start to see the beginning of the right to privacy. And then Roe moves it back to the 14th Amendment and places abortion within that broader right. Next, let me come to Damien to talk about the concurring opinions.
Sure. So instead of finding that the right to privacy, or I'm sorry, this is Goldberg's.
Yeah, and then we have Holly for the next one.
Sure. And instead of finding that the right to privacy in marriage was contained in abstract penumbras, he emphasized the Ninth Amendment and said that more liberties are protected under the Fifth and 14th Amendments than those listed by the First, Eighth, Amendments would imply, and concluded, to conclude otherwise would nullify the Ninth Amendment. And I assume from that, of course, that would violate the framers' intent, and I extrapolated a bit from his concurrence that it would violate the framers' intent and basic statutory interpretation principles.
Good. So this this concurrence is really interesting. He actually offers it again in Roe, and then he dies. And it's noteworthy because at the time, the scholarly debate suggested that this is the textual version. So for all the critiques of Roe that say, where in the Constitution does it say this? Many would then have pointed to Goldberg and said, well, if we had gone with the Ninth Amendment, we could say that by default, this was a right that the people held. So ultimately, it's a tiny little historic moment that this Ninth Amendment argument lives as a possible home for the right to privacy. And then, Holly, where does Justice Harlan put it again?
So Justice Harlan says that the proper question here is whether this statute infringes on the due process of the 14th Amendment. And he says it does because it violates basic values that are implicit in the concept of order to liberty.
Beautiful. So this case sets out for us the right to privacy, places it in this penumbra of rights emanating from a number of constitutional provisions, but we see the debate happening of competing perspectives. Justice Harlan still remains super important because he ultimately bridges us into Roe. And Olivia, tell us about the two dissents here.
Yeah, so Justice Stewart and Justice Black joined to say that they both agree that this is an uncommonly silly law, and as a practical matter, the law should obviously be unenforceable, except in the oblique context of the current case. They both say they believe the use of contraceptives in the relationship of marriage should be left to personal and private choice. But then they go on to say that the case isn't being asked about their personal opinion, policy or morally wise. It's being analyzed whether it violates the Constitution or not. And they say there's no explicit right to privacy stated anywhere in the Bill of Rights.
Good, perfect. So these are the critiques we come to know really well. So Griswold is a super important case, giving us the right to privacy and placing it in the penumbra emanating from a number of other textual constitutional provisions. But notably, who holds the right, if we think about this in relational terms, married couples. So that brings us to Eisenstadt. So Adam, how does Eisenstadt change everything about what we just studied? Or expand what we've studied? Is Adam on here? Is Adam here? I don't think he is. Does anyone want to volunteer to tell us about Eisenstadt? I can summarize it if we need to. Our class roster was a little off. Does anyone want to volunteer? Eisenstadt is super interesting. I'm going to actually put up my Conlaw slide to show this. Eisenstadt is super interesting because everything we've said about Griswold put this in the marital relationship. Eisenstadt doesn't require anywhere near as much time. It actually comes at it from an equal protection lens. So an equal protection lens, especially focusing here on our 2Ls, an equal protection lens looks and says that similarly situated groups should be treated similarly. Whereas fundamental rights are identifying a right and then looking to see whether the state provides the proper level of regulation that correlates with that right. So Eisenstadt comes in and says, unmarried people should be treated the same as married people for the purposes of accessing contraception, and the court agrees. So if we go back to my conceptualization of the right to privacy along relational, decisional, and locational lenses, Eisenstadt breaks that married person part out of it and says this isn't about married people. This is about the individual right. And I hope as you're hearing us talk about that, you can see how that's going to be a very important bridge into Roe v. Wade. But ultimately, it's an equal protection case that tweaks Griswold and says everything Griswold says has to apply to single people too. It is not about marriage. So let's jump. So let me stop and ask if there's any questions. I know we're moving quickly and I talk fast to begin with on a normal day. Any questions on where we are so far? And then we'll move to Roe. Somebody give me a thumbs up in the bar. Are you guys awake? Are you drunk? Are you sleeping? Everybody good? Yay, thank you. Okay. I need validation. Yes, DJ, what's your question?
I feel like it's the right to privacy issue is still it still exists in medicine today. Like, my sister-in-law basically found out she was pregnant, but because she was told that she couldn't be sterilized because she was too young, and she knew that she didn't want kids, and that was never in the cards for them. But she was still denied access to it. And I worked women's health care, and our provider didn't like taking younger patients because she didn't want to touch this because she was super religious. And she had someone come in and she's like, I'm not going to see you because you want to discuss like contraception for contraception's sake. And, that kind of stuff. And I feel like it might be a little bit less statutory, but it's still like super prevalent. And I don't understand how that is allowed to jive, I guess.
Yeah, and we'll talk about, it's a great question. And there's lots of statutes that come in and protect privacy as well and create tensions, right? So you'll study in constitutional law all sorts of statutory frameworks that protect religious freedoms and allow for things like conscientious objections from pharmacies or nurses interacting with particular healthcare decisions. So a lot of what you'll study in a proper con law class will be how some of these rights start to clash and start to conflict in the way that the court will wrestle with them. For our class, I do think it's kind of interesting, though, that we're even talking about the right to privacy, because if you think about family law and you go back to like the Meyer-Pierce case, or we look ahead to next week with Loving and Obergefell, there were espousing rights that just sit so squarely in the family: the right to raise and rear your children, the right to marry, the right to privacy. I acknowledge fully, and I think it's important for us to all acknowledge, regardless of our political perspectives, this is just a clunky fit, hard stuff, whatever your politics, either because you don't want there to be a constitutional right here at all, or even if you do, it's still not a good fit. It was an awkward fit from the beginning. And I hope you appreciate how much time we spent on that to see that this is a bizarre coalition of factors leading to this privacy frame, but it doesn't really actually fit at all what we're talking about. And so just to jump ahead, the dissent in Roe, I think, is awesome. I think it's Rehnquist comes out and he says, what are we talking about with the right to privacy? We're talking about a medical procedure happening in a building. Is privacy really the right word here? And if we were to go back to Poe, the advocates would never have used that word ever. So it's a really interesting lens. But it's very murky. So for common law purposes, for class purposes, the best thing that you can take away from this unit, and by the time we get to the end of it, and I should mention as well that we spend 3 weeks on this, 2 weeks learning material, and the third week we spend our entire Thursday night together doing practice problems. So we will practice and apply these concepts quite rigorously. But the key thing that you should recognize for your purposes, where you have to get to with this material, you have to get to exam readiness. You will make the arguments for the petitioners, which always want the right to be as broad and as inclusive as possible, and the state defending its statute will always want to make the rights as narrow as possible. To limit the right to privacy as much as possible. And so we'll talk about that more, but really focus here on mapping arguments to who would make them in a modern context. So let's jump to Roe, and I have Davis to kick us off with this case. So Davis, start us off by telling us about the statute here and what happened in the background.
All right, so we have Jane Roe, which it's not a real name, it's a fictional name. And she filed a lawsuit against Henry Wade, who was the district attorney for Dallas County in Texas. And basically she was challenging a Texas law making abortion illegal except by a doctor's orders to save a woman's life. And then so in that lawsuit, she alleged that the state laws were unconstitutionally vague, and basically that they were in violation of, she lists a bunch of rights, 1st, 4th, 5th, 9th, and then really what the focus is on is the 14th.
Good. I'm going to stop you right there for a second to applaud you. First of all, just a random, shallow, pathetic note. Did you guys catch in Poe v. Ullman that there were 3 families, and they were the Poes, there were 4, the Does and the Hoes. Sorry. Sad, but who thought that was a good idea? Anyway, so I definitely would not enter a party as a case with that name as the plaintiff. So many things to celebrate about what you just said, though. Did everybody hear how many examples Davis listed? They're bringing it under the 1st, the 5th, the 9th, the 14th, the 9th. They're just throwing it all in there. Why are they throwing it all in there? Because of all the work we already did earlier in our class, talking about the majority, concurrence, dissent. You can see why this case becomes the cluster that it becomes, because these litigants are in this bizarre situation where they have several justices who support placing this right under the 14th Amendment, several justices who supported the penumbra argument. You've got the 9th Amendment guy still alive, and you can see why it's like if you throw yourself back to writing your appellate brief, it's like point heading 1. If not that, let's try this. If not that, let's try this. So they place it all over. And that's really notable because it's coming out of all the concurrences we spent time developing in Griswold. Now, Davis, tell us a little bit about some of the history the court gives us. What does the court tell us? And more importantly, why do you think they're talking about some of the history here of abortion regulation?
Well, I think in part it has to do with, all the claims that they, brought into action because the plaintiffs kind of covered the basis with all of that. So obviously you have to kind of hash out the history to a certain degree because as such was a big case, you kind of have to lay a foundation in order to go where you're going to go. And so basically they talk a lot about the right to privacy and so how it protects a woman's choice, whether to have an abortion, And then they also kind of get into how they talk about that exception.
I'm going to pause here just for a second. I've popped up here. My screen gets scrunched together when I put it on this way. I don't know if there's a way to fix that, but I apologize for the formatting. I'll send the slides after class, and they look fine when you open them outside of here. But we're talking about a number of different lenses, 3 different lenses that the court can use when it looks at a statute, the constitutionality of the statute. One lens, the strict scrutiny, it will look with the narrowest lens and require the most carefully exacted laws, rational basis where it's a presumptively constitutional law, unless there's the law is just so clunky and out of whack. And so ordinarily, and we'll develop this concept much more next week, but ordinarily, the first question you'd ask is, what level of scrutiny are we applying? And so, because then it would shape what we're looking for. So when we talk about government objectives, we would be looking to see, are the government objectives compelling, or do they only have to be legitimate? And one of the first things I want to highlight here is the court begins, so a perfectly constructed constitutional analysis, like the one you will do on your exam, will begin by saying, here's the right that's implicated. This is the fundamental right. It gets strict scrutiny, for which we first look at the government objectives, and they have to be compelling. And then we look at what the statute actually does. This is terrible drawing. And we look to see if it's really carefully tailored to be as tight as it can be. Notably, one of the first things to take away from Roe is the court starts talking about the government interest, but it never tells us what the standard of review is. That should catch our attention, because normally we'd want to say, well, can we just pick something? Does it just have to be legitimate? Does it have to be really compelling? The court begins by giving us 3 government objectives, the reasons why it passed this law. And what are those government objectives, Davis?
I'm sorry, can you repeat the question again?
Yeah, so what does the government say is the reason why it passed that law? Why is it doing? Who is it trying to help? Who is it trying to protect? And
part of it is they're trying to protect they're trying to establish their own interest, which is why you see in Blackburn's opinion, he goes through the the first trimester and the steps to how they figured that out as well. But they're also trying to protect the woman and the child in the process.
Good. Oh, there's really three, but the first we can do away with, this Victorian thing. Then we are protecting women in the health interests in protecting pregnant women. And second, we're protecting potential prenatal life or fetal life or whatever word you want to use. But there are multiple interests at stake here. Let me switch. Mary Beth, I think I have you on call for this as well. What does the government say about what does the court say rather? Does the government have an interest in regulating women's health?
Yes.
It says they do have an interest. Are you talking about like Texas, or are you talking about the Supreme Court?
I'm talking about what the Supreme Court says about Texas. Can it regulate? It says it's regulating to protect maternal health. Can it do that?
The court says that it can.
Good, of course it can, right? That shouldn't even surprise any of us. Of course it can. There's all sorts of regulations about clinics, your doctors, and what kinds of protocols they have to follow, kinds of reporting measures. All sorts of ways in which we regulate maternal health. So the government does absolutely have an interest in it. Now, the next question, though, is when does that interest become compelling? If we think about the continuum of pregnancy, does the government have a compelling government interest always in maternal health, or when does it flip on?
Well, they start to talk about the trimester, kind of like the progression of pregnancy. And what I took from the majority opinion is that, let's say a woman is, it's before the first trimester ends, the interests lean more towards the woman's choice. However, once you get past the end of the first trimester, the interest of the government and of the state regulations increase significantly. So it's kind of, I feel like the government obviously has more control over the woman than the woman has to decide, but that's basically what the court says. And the court even says that Roe, she's saying that she believes that a woman's right is absolute no matter what. And they blatantly say they do not agree with that.
Good. Absolutely. All of this is a conversation about competing rights, the rights of pregnant women, the rights of the state, the rights of the fetus here. And the court is constructing a continuum. And so I want you to think about, first, my drawing is really, really sucky on here, but I still think it's helpful. I love my whiteboard in class, and I'm missing it right now. But I want you to think about this as a continuum. And what we're really talking about here is when the state's interest, the state is giving us two stated interests. The first is the interest in regulating women's health, and the second is the stated interest in regulating potential prenatal life. And I'm going to talk about my word choice there in a second. And the court tells us that when it comes to regulating maternal health, that right becomes compelling at the moment of the first trimester, right here. And part of the reason for that is because that's earlier, it's safer to have an abortion than it is to give birth, going back to why I embedded some maternal mortality context into our class. So starting here, now the state, pardon my bad drawing, but this is a regulation. Now the state is free to come in and pass all sorts of laws regulating maternal health. Next, Mary Beth, let's talk about its interest in protecting prenatal life. When does the courts, first of all, when would the state want that interest to become compelling? If we're talking about from conception, I don't know what that is, a zygote, I don't know what that is here, through to birth down here, when would the government want that to become compelling?
At the point of viability of the fetus. So if it could live outside of the womb.
I'm sorry, that's the court. Let me use different language. When does Texas want it to come? You're absolutely right on the much harder question.
So Texas wants it to be at conception.
Good. So Texas wants it to sit right here and say, from the very beginning, and I hope you're mapping these to modern arguments, from the very beginning, the state has a compelling government interest in regulating potential prenatal life, dating going all the way back to here. And when do the petitioners, who in this case are speaking for Roe and for women's groups more broadly, when do they want the state's interest to become compelling?
So what I'm wanting to say is like whenever, but let's see.
When would they say that there's officially a constitutional person? Another way to say
it. Viability? I don't know.
They're going to go even further than that because they're concerned about the idea that the government could be regulating. Like if I could draw a pregnant woman, that's what that is there. Yeah. They're concerned about this idea of a patient. Just looking. I don't know what that is. But they're concerned about the idea of a patient within a patient, right? So the women's groups are going to be uncomfortable putting an interest inside of another constitutional person, right? So they would say the moment of birth, we have a constitutional person, and that's when the state's interest can become compelling. But more importantly than my terrible drawing here, back to what you first said, the answer sat right there at that second trimester. That at the moment of viability is the key word. That's when the state's interest in potential prenatal life becomes compelling in the Roe opinion, because that's when the fetus is capable of life outside of the womb. And let me see if I have a better slide than this one. Okay. So it's recognizing these two rights. Now, next question, Mary Beth, so all of the time the court has been talking about these government interests. What constitutional source does the Roe majority, where does the court house the right to privacy? Where does it find its constitutional home?
Was it the 14th Amendment?
Good. It switches it, right? So it moves it from where we put it in Gonzalez right back to where Justice Harlan wanted it in the 14th Amendment substantive due process. And what the court says is, it says whatever this right to privacy is, back to this kind of outer boundary visual, whatever this right to privacy is, it includes the right to terminate a pregnancy. Now, the most important question of the night, does the court ever say that the right to terminate right to abortion is a fundamental right?
No.
Chat, yeah, no, talk about it. What does it say? It gets really close.
I know exactly where I saw that. I'm trying to find it.
I think it's probably the same quote I was just reading. It says that the fundamental right to privacy is so broad that it encompasses a woman's decision whether or not to terminate her pregnancy. It's the closest that any U.S. Supreme Court case will ever get to positioning the right to abortion as a fundamental right, but it does it by sort of mapping it in to this right to privacy. And one thing I want to just briefly mention before we move past Roe is notably the court says in Roe that some would phrase the state's interest in fetal life as a duty. And I want to make sure I just mention that, because as we think about where abortion politics are going, the court in Roe unequivocally put these two rights, the right to maternal health and the right to potential prenatal life, and gave them pretty equal treatment. We're about to look at Gonzalez, where we're going to see a huge swing in the way in which the court positions the two rights. So let's talk for a moment, but we won't spend much time on Gonzalez. The reason I want to spend some time on Gonzalez, hold on one sec. I'm jumping way ahead. I skipped the dissent. Let's talk about the dissent. So we leave Roe. let me go back. Let me pause, slow my roll here. We leave Roe with a couple significant takeaways that I want to make sure I emphasize clearly. There is a constitutional right to privacy, and it does include the right to terminate a pregnancy. The constitutional source for that right is the 14th Amendment, liberty, notions of substantive due process. And then it's getting really close to saying that that gets the highest rigorous levels of scrutiny. And we're about to rip that away in Gonzalez in a moment. Last question for you, Mary Beth, or for Davis. If we go back to thinking about the right to privacy on locational, relational, and decisional lenses, which of those are implicated here?
Would it be decisional?
Yeah.
Decisional, and whose decision is it? Is it a decision of the woman?
The pregnant woman?
Is it her decision alone?
No.
Who's with her?
And we're still talking about Roe, right?
Yeah, sorry.
Okay. Well, it also has to implicate the state and government's interests, I guess.
Why don't folks weigh in the chat bar there? Who holds this right? Gonzalez put it with married people. Eisenstadt ripped it away. It's really the doctor's right here. There are spots where it says doctor only, and there are spots where it says in consultation with the doctor. It never, notably, the relation at stake here is not the pregnant woman and the baby's father. That is not the relationship at stake. It's the doctor in relation to the pregnant woman. That's the relation. And the decision is a medical decision held by the doctor and the woman. There is not a single spot in the entire Roe decision where it ever positions the right as the pregnant woman's right alone. And that's really important. Dimitri, tell us about the dissent here in Roe as well.
Hello, Professor. Can you hear me?
Yeah.
Okay, awesome. Great. The dissent was, it was great. You talked about it a couple times, but it challenged the majority opinion in a few ways. So first, Justice Rehnquist talked about how the act of abortion is less private than the other privacy rights that the court has used to define the term privacy in the past, and you spoke on that earlier. Second, the dissent states that the fact that a majority of the states have had restrictions on abortion for at least a century is a strong indication that the asserted right to an abortion is not so rooted in the traditions and conscience of our people as to be ranked as fundamental. And this reminded me, I think it was Justice Black's dissent in Griswold, where he says that Justice Goldberg has adopted a recent discovery that the Due Process Clause can be used by the court to strike down all state legislation which the court thinks violates fundamental principles of liberty or is contrary to the traditions and collective conscience of the people. And then, I'm sorry.
Good. Perfect. Yes. So lots of robust public critique coming out of Rehnquist suggesting, and it's going to carry all the way into Whole Woman's Health, suggesting where is the textual basis for this? What are the limits of this right? And these are fair questions to ask regardless of your politics. What are the limits? The entire reasoning of Roe v. Wade is whatever this right to privacy is, it's broad enough to include the right to terminate a pregnancy. But then the next question is, well, if that's true, what else is it broad enough to include? I'm going to make two more points before we wrap up. First, the opinion in Roe and all of the hard work that we've begun to develop takes a considerable turn in Casey. And Casey is not meaningfully discussed in your casebook because it ultimately gets swept into either Gonzalez or Whole Woman's Health, depending on your text. But I want to make sure you can cut and paste it straight from this slide if you need to. But this becomes the new language. So just to compare and contrast, ordinarily, when we think about fundamental rights, we run them through this pretty neat and tidy analytical mechanism. We say, what are the government's objectives? What are the means chosen? And you work through step 1 and step 2. Casey, an opinion we won't spend much time talking about, comes in and says, that's all really messy and all this trimester stuff, and it's all very temporal and this continuum in my bizarre pregnant woman drawing. Comes in and says, here's the test for the right to privacy. When a regulation imposes an undue burden on a woman's ability to make the decision, that's when we flip the switch. If it poses an undue burden, and the definition of an undue burden is presented in my second paragraph here. Something that has the purpose or effect of placing a substantial obstacle in the path of a woman seeking it. That's when we flip the switch. So we ultimately move away from this trimester framework that we studied, and we say, well, what's really going to flip the switch is if the state action, the law or regulation that we're talking about, puts an undue burden on this decision. So what we're going to do, I want to be very, very sensitive to everyone's time. So what we're going to do next week when we meet, the Gonzalez and Whole Woman's Health are the two most recent cases, and they also actually present a perfect opportunity to review everything that we studied here as a setup. So we'll come back next week and we'll pick up. I know I still have Ethan, Juanita, a number of other folks on call. So those folks will pick up, and we will talk about Gonzalez for 5 minutes and Whole Woman's Health for 10 minutes, and then we'll move into our material. Our first class takes a little bit longer because we're developing these rights. Next class is really part 2 of this same material. So your reading should go quicker. You should have a more rigorous lens when you critique this right to privacy in Lawrence and the ways in which fundamental rights are analyzed in Obergefell and Loving next week. So we will stay on top of our material. I know we moved quickly. Think of this as a 3-week unit. We've done 1 week. Next week, we'll keep building on this. And that 3rd week in person, we will do a rigorous full 75 minutes of practice problems, applying all of these doctrines and cleaning up anything that we move too quickly through. So I'm going to formally end our class, but I have tons of time. So I'm going to stay here and answer any questions and just check in with anyone who has questions, but I'm going to formally stop shouting at you. You guys are wonderful. Keep reaching out with great questions. I'll see you same time, same place next week, and keep reaching out. Reach out by text, reach out by email if you have any questions with the material as you go. So class is over. Question. Anyone have any questions about all the craziness we just did? Dimitri.
I'm sorry, my computer froze for a second. I think in week, I was looking at the syllabus, I think in week, I want to say 4, but let me make sure. Oh no, it wasn't 4. Week 6? Okay, week 6, one of the readings says 691 to 796. So
I'll look at it. What week is that?
That's
6.
Week 6, yes, ma'am.
I apologize. I don't look at that. I definitely am not. I usually do assign about 20 to 30 pages of reading for this session, but I'll go back and fix that. I'm mortified.
Oh, that's
600 pages is a little much.
All right, thank you.
Sorry about that.
Have a good one, too. Bye.
You too. Take care. Brian, Annie, Liz, some of the two.